Now, your Lordship may not have looked this time, but earlier Lordship saw. 4, 5 and 6 are very interesting clauses. The defenses are very limited now. 4, 5 and 6 are the only defenses. As my Lord knows, there was 3, which is conspicuous by its absence by the 91st Constitution Amendment of 1104 that deleted clause 3, the split. Now just see the nature of the defense, fellows. 1, merger. I'll not read it. That's fellows clause 4. Now merger, fortunately for all of us, is not even alleged or pleaded or claimed by them. Forget your Lordship finding merger. It is not their case. Second exemption is, well, it's a kind of a sympathy condonation. If he rejoins, there are cases where the person will rejoin. So you have a provision by which he can be let off. That is 5. And 6. Actually, it's only 4 and 5. Sorry.
Only 4 and 5.
3 was there earlier. Sorry. Now, that brings me to the 4th bullet under this. What is the purpose of this? Well, your Lordship will read Mr. Ashok Sen's speech when 85, this was brought in for the first time, 10 schedules. Well, he said all this constitutional sin, stigma, purity, all that is there in that speech.
Ayaram.
That has happened, Malus. There were 2 actual names of actual MLAs in Haryana in 1967. These are the names of actual 2 MLAs. That's how this phrase has occurred. Now, he cites all that. Then your Lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Well, as your Lordship is, with great respect, thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. Of everybody leaving, except the Chief Minister and the Speaker. Theoretically, it can happen. But well before that, everybody will leave, including the Speaker, or he will be removed, as Sibal said. So it doesn't really arise. It will not, should not come into your Lordship's analysis of how to deal with this Nabab issue. The object is that as long as even the majority, or large number, or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defenses were being used. So, therefore, it's a per se doctrine. In a per se doctrine is the 5th bullet. The Speaker has to get only 2 things, Kindly note that. What does he have to get? Why? He has to get, any evidence of voluntarily giving up or voting or abstaining. They're the only 2 categories. Now, second is easy. There's a whip to be shown. You absented yourself or did not vote. The first one is, your Lordship is interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium with giving speeches with the opposition. All the judgments are there. So the Speaker must act if the 10th schedule is a constitutional sin prevention. Your Lordship cannot allow the other side to ask him, you can act, but you may be biased. May be biased. So that's my second point. My third point is, this alacrity point. And I'm not on the general point which your Lordship asked, but on the particular point which both Chief Justice and Justice Narasimha asked, on the notice period. Your Lordship said they may have some relevance to what is the notice period which the Speaker gives. Now there, just for the record, your Lordship asked that question. Just note down this and then I'll give your Lordship. There are 3 judgments which are very important. Lordship, note down that I'll give your Lordship. One is Ravi Nayak. It's a division bench from Goa. 1994 Supplementary 2 SCC 641. PDF 191 of the CC1 case law compilation.
Supplementary 2 SCC page?
94 Supplementary 2 SCC 641. It starts as your Lordship's compilation of cases as PDF 191. And the relevant part is para 24 at PDF 204. Don't go to it, just give me a minute. Don't go to it now. The second judgment is Yedurappa, which is not in any compilation that I know of. Just note the citation, need not go to it. 2011, 7 SCC, page 1. Both of these, Ravi Nayak and Yedurappa, are division benches. Both are division benches. The judgment I'll take your Lordships to, which covers these 2, is Srimant Patil, which is 2020, volume 2 SCC 595, PDF starting page 1249 and relevant paragraph 109 to 112. The ratio is in 112 and the PDF page is 1292. Now note, well, two things before I read that last judgment only. Goa, which is Ravi Nayak, has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Shivan Patil, also have 7 days. So Karnataka rule is the same as Goa. The actual notice in Ravi Nayak was 2 days. So less than the rule prescribed. This has great relevance to both the Honorable Chief Justice's query and Justice Narasimha's recollection on that, which is important. In Yedurappa, 3 days was given and Shivan Patil, 3 days was given. Again, the rule said 7 days. The nub of the matter is that in Srimant Patil, the 3-judge bench said that what is important is not just the text of the 7-day rule in the legislative rules. The legislative rule will not be mandatory and will not be dispositive. What matters is that because of the urgency and the constitutional sin involved, did he get an effective chance or not? If he gets an effective chance in 3 days or 2 days, it is enough. It's reasonable opportunity. This also sets a record straight because it is not as if Yedurappa is ruling. It has been distinguished and in fact, in that sense, not followed by a 3-judge bench. Kindly see this in the judgment's compilation. Just the last one will suffice for us. At page
129 is only about whether under disqualification inadequate notice.
Compilation 1.
Case law compilation 1, 1292.
Internal proceedings of the House which you are mentioning. You will enter
129.
leave us its disqualification maintain a supreme of the House of the
This is all based on alacrity.
Sriman.
2 days, 3 days, urgency. Of course, even 10 days may not be effective.
He was present on that.
I'm traveling in Iceland and I get 8 days notice. I may not be able to. And I'm right there, I know everything is happening, then 2 days is enough also. So 109 it starts. The relevant is only 112, but let me just read 109. May I read?
Yes.
At page 1292. My lords have got it?
Yes.
The petitioners contend that the principles of natural justice were breached when the Speaker provided for a 3-day notice in derogation of 7(3)(b) of the Karnataka so-and-so rules, wherein a 7-day period is prescribed. On the contrary, the respondents have emphatically stressed on the fact that there was adequate opportunity given to the disqualified members to make out their case before the Speaker. So look at the rival contentions. Counting the days in a sterile manner and the actual effectiveness of the opportunity or adequate opportunity given. That was the rival contention. Principle of natural justice can be reduced to the straitjacket formula. The yardstick of judging the compliance of natural justice depends on the facts of each case. In Das, it is well established, then they quote Das first. This court in Kyoto held that Speaker decides the question as to disqualification adjudicatory disposition. This view received further elaboration by this court in Ravi Nayak. An order of an authority exercising judicial or quasi-judicial functions passed in violation of principle of natural justice is procedurally ultra vires, therefore suffers from a jurisdictional error. That is the reason why, in spite of the finality imparted to the decision of the Speaker chairman by 6-1, such decision is subject to judicial review on the ground of non-compliance with the principle of natural justice. But while applying the principle of natural justice must be borne in mind, they are not immutable but flexible. They are not cast in a rigid mold, cannot be put in a legal straitjacket. Whether requirements of natural justice have been complied with or not has to be considered in the context of the facts and circumstances. At this point, the petitioners have placed reliance on Yedurappa. This was the rival view, and argued that in that case, this court had struck down the disqualification order solely on the basis of the fact that only 3 days' notice was given to the members. Now the 3-judge bench leans in favor of Ravi Nayak. However, it is relevant to point out that Ravi Nayak's case, a disqualification order wherein the Speaker had granted 2 days' notice to the members, was upheld. The question is therefore not the number of days that were given by the Speaker for answering the show cause, rather to see whether an effective opportunity of hearing was provided. This brings us to the point already reiterated and not a straitjacket formula. So, this is the overwhelming alacrity fed into all judgments of 10th schedule because of the overall object. And one last thing here about alacrity. There is a judgment of your lordship from Maharashtra, I believe. Jalmi from Maharashtra. Jalmi versus Speaker. 1993 to SCC 703. Give me the PDF page. PDF
168.
page. Same compilation, PDF 168.
93?
1993 to SCC 703. Para is 20. The starting page of the PDF is 168. Para 20 is at PDF page
179.
179.
Reconcile this principle which is representing the speaker.
There is no indication in Vrindavan Nayak 65 that the delay in raising the question of disqualification provides justification for refusing to decide the same. And the emphasis really is on a prompt decision by the competent authority on the question being raised, since it is not in the interest of the constituency which such a member represents to delay the decision. It's the other way around. One of my friends argued that the constituency will become vacant. On the other way around, the cloud should be decided this way or that way. This decision is an indication the authority competent to decide must act promptly in deciding the same. Once it is raised even by a citizen in order to prevent a disqualified member from representing the constituency after incurring disqualification subsequent to his election, so long the question remains a live issue during the tenure of the member. This is dealt with. This is on general promptness. I am not on the case today. It's on general promptness. Now, Malus, two more things that I have done. One is, Malus, I believe Mr. Marinder Singh read Shivraj Chauhan or Mr. Jethmalani. That I am not getting into, Malus. There are two delightful paras there which are directly in my favor. Shivraj Chauhan, which I had the privilege of arguing before a bench of which my Lord the Chief Justice was a member, was a reverse case on facts. But your Lordship accepts today's principle in the very para my learned friend has read. Can you turn to that for a minute? PDF 1390, para 80. The principle your Lordship accepts, but the converse set of facts, it applies in the reverse.